So, hello everybody, and welcome to this week's episode of Save Our Schools with Dear JCPS. We are in a makeshift studio again this week. The Hayburn building is still inaccessible. The 8th floor of the Hayburn building is still inaccessible via the elevator. So we are actually at my work in the embroidery room because they have really powerful embroidery machines. I think
Anyway, wherever it is, here it is. See, no lie.
That's the embroidery thread. And so they've got the room soundproof, so it actually makes a pretty good studio. We're happy to be here. As usual, Yvonne Rivera is my sidekick here with me tonight. And our guests, we're very excited to have Anna White and Amye Bensenhaver. And I'm going to tell you a little bit about both of them, and then I'm going to let them tell you more about themselves. I've known Anna a little bit longer than I've known Amye. Can you hear me?
Yes, I can. We can't see you. Can you see us?
I can see you. We can see you and hear you.
Okay, perfect.
There's a little pop-up box that may be a setting you can change so that whoever's talking usually becomes.
Oh, okay.
Maybe not. As long as you're in frame, I think we're okay.
Okay.
So I've known Anna a little while. She's an attorney out of Frankfurt, and she works in the medical field mostly, from what I understand. But she's been a great resource for us for some of our questions that we have on legal matters. So we really appreciate her being an ally and accessible for us. And Amye Bensenhaver, who I just met a few weeks ago, I guess, is a former assistant attorney general. Did I get that right? Yes. Okay, and she's also when I heard her name, it always comes with the term open records guru. True. In fact,
Roy said so too.
Yes, he had heard of you. So she's, as far as I know, the foremost open records guru in the state. So we're very fortunate to have her with us tonight, and her expertise as well on some of the issues that we've been talking about regarding open records. If you've been following our program, you're aware that we have been making some open records requests of the district through the district of PTA. And we had a situation where the PTA learned of the open records that we requested from the district and filed a complaint for injunctive relief. I'm learning all these new terms. And it was intended to stop the district from turning over the records that they already have in their files, in their possessions, that are part of public records. So Amye is going to tell us a little bit about what she has read and heard.
I need to do my sidekick interruption.
All right, yes.
I'm always, my one thing that I do is, for our listeners at home, that's what I'm always saying, for our listeners at home, how is it that you went to JCPS initially instead of PTA? Because there's a reason for that.
Well, there's lots of reasons, so I'm not sure which one of them you're fishing out
of. It's one place instead of.
Exactly. It already exists. I was reading in Redbook that the PTAs,
which is the PTA's Bible,
right? The regulations that govern these outside entities, the financial management of these outside entities in particular. And I was reading that every PTA in every school across the state is required to file a preliminary budget at the beginning of the school year and a financial review form at the end of the school year. It's a one-page summary of the money they brought in, money they sent out, any outstanding debts or receivables, and some signatures. So because those documents have been collected every year as part of the school audit, I knew they already existed. I knew they were part of open records, and I made a request to go to a single point so that it wouldn't create a whole lot of work for 150 different schools and 150 different volunteers, especially when I wanted 5 years worth of these records. And
was there precedent for this?
Well, hold on, let me finish.
Oh, sure.
The 5 years thing. We know that there's a lot of turnover in PTAs. It takes less than 5 years for your child to go through high school, for example. So you wouldn't have most likely the same leadership from 5 years ago. So asking the current new president, because over the summer there's a lot of turnover. So
yeah, we have a new president this year.
So asking that new president to track down 5 years worth of leaders and recollect data that's already in existence. I mean, it just didn't make any sense to me to go directly to the Kentucky PTA to ask for this, but that was their concern and their argument. And then the precedent question that you asked, yes, the Courier Journal had requested these exact same records in 2017 and didn't have any problem getting them turned over to them. So I kind of rambled in setting it up. I want to give Amy and Anna a chance to introduce themselves a little bit more in detail, but we wanted to set the stage and explain why our guests are relevant to tonight's program and what we'll be discussing. So Amy, why don't we start with you?
Okay, what specific feature of this would you like to address? Just generally the background for open records and why this should be accessible?
No, who are you? We want to learn more.
Who am I? Okay. Well, first of all, I have to emphasize that I share the title of Open Records Guru with several people. There are a lot of people in Kentucky who have a really great mastery of this area of law, but I was fortunate to work for many years in the Attorney General's office on this particular issue. So I did develop a breadth of knowledge that is somewhat unusual. It's also kind of like very specific to one area of law, but it takes you into so many other areas of law, including in this case, records of a school district mandated by regulation to exist within the school district. And that was what was, kind of interesting to me. Is I think your approach was a really good one, because it, isolating that school district and that source of the records actually, I'm sure, simplified it for everybody until this dispute arose about your right of access. So
yes, and I know you've written some opinion pieces. I found some of your articles in various Google searches that I did. So you have written extensively, as well as not just in the paper, but opinions for the Attorney General's office. Is that correct?
Right. Yeah. Of course, that was my career. For 25 years, I wrote opinions. The Attorney General has a role in resolving disputes that arise under the open records law. And basically, it's like a court that the matters are resolved. The decisions, if not appealed to circuit court, are legally binding. They have the force and effect of law. So essentially, that was my function. And I once estimated, and it was an estimate, it was about, I would expect at least 2,000 opinions over that period of time, because the Attorney General really does receive a lot of appeals annually, and he issues at least 250 decisions a year. So yeah, that was my job. And so it gave me a sensitivity to the competing the tension between the public's right to know and the challenges for a public agency. But here it's not. What's unique about your situation is this agency is not asserting that there's any right that's compromised, that they're in any way unhappy with having to disclose these records. It's an outside entity that's coming in to block disclosure, which is a relatively rare situation. So rare, in fact, that it appears that the court was unfamiliar with the precedent that exists that may have governed this case.
Right.
So, yeah.
And it's a dangerous precedent to set going forward as well, don't you think?
Yeah, I do, absolutely, because I feel like, the reason we have a regulation and a reporting requirement, and as you pointed out in the brief, there has been apparently some awareness in the past of a need for accountability. I'm not going to target specific instances. I don't know of specific instances in which, there have been allegations of, misappropriation or whatever, but there needs to be that accountability, and that really is what the open records law is all about, is accountability and transparency and the ability of the public to monitor how agencies are discharging their functions. And in this case, you have a right to know that JCPS is properly collecting and making accessible to the public these financial reports that are required by regulation.
And this type of situation, Anna White, like Gay said, primarily a healthcare attorney and have Anna White's law office in Frankfurt. But I also do a lot in the political sphere, living here in Frankfurt in our capital. And you can read about that on my Miss Anna for Kentucky blog. But I see open records requests on the other side as the attorney for hospitals or large employers, and we get media questions about open records. Can we see what your CEO makes, or can we see your policies for emergency room care? There's always somebody who would rather you didn't release those records. And so even if my client says, okay, they're standing in the JCPS role, and they're like, sure, this is a public record. The law says that public policy should be open to the public. And so they're ready to release it, but there's always an employee or a vendor or somebody who wishes that wouldn't get out. And so while this situation is unique, we and the court should recognize there's always going to be somebody who does not appreciate this being public.
Right.
And that's why the statute really requires that the exceptions be very, very narrowly tailored and very strictly enforced, because I cannot think of an open records case in my career, having worked for employers or taking them to court, where there hasn't been somebody who did not want it released. There's always someone who doesn't want it out there, and that's not always the agency or entity who's receiving the request.
Right, and I will say, you know, I literally write this so much, I think people are probably getting really tired of me repeating this, but, you know, the legislature in enacting the law essentially said free and open examination of public records is in the public interest, even though that examination may cause inconvenience or embarrassment to public officials or others. So, you know, that's sort of the overriding principle. That's the overarching guidance for the courts in construing the law. And again, in this case, JCPS has no objection to disclosure. And I can tell you that isn't they're not an agency that is just delighted with the notion of releasing records, you know, randomly. And yeah, they are not going to not take that responsibility seriously for ensuring that record doesn't need to be protected. So that's what's ironic about this situation. And although not entirely unique, it is somewhat unique. There's case law in which this has occurred before. There are instances where it arises. This is somewhat unusual because, again, these seem like to be fairly innocuous records.
That's what I would think too, but the fact that they are trying to stop me from seeing them makes me think otherwise.
I have a question to something posited by Coy Travis. And let me begin by saying he is a very nice man.
He was very nice and very generous to be on our show last week.
Yes. And he compared these records to income tax records, which he said, people knowing your income and your address and whatever. And of course, there's a book that has, I was a journalist in a previous life. And in the newsroom, they had a book that had everybody's address in it. You just went and looked them up, whether they had a phone number or not. It wasn't based on the phone, were you in the phone book? They were all in there. So that's a public record that you live at 123 Happy Street. Does he have any how is his argument based on the budgets of the 150 PTAs?
I'll tell you exactly what I think. Income tax records are jealously protected by separate statutory enactment. And I can tell you the statute, it's KRS 131.190. It erects an impenetrable barrier to access to private income tax records. But basically, you can't get them. Absolutely. The penalties that exist in that law, if a revenue cabinet employee discloses that, I describe them as draconian. They're some of the harshest penalties you can imagine. So those are very closely guarded records. But financial reporting is generally not so protected. And the unique aspect of this, of course, is that the PTAs are not, well, let me say this. I do not believe the Attorney General has ever determined that they were public agencies, but they're discharging duties that involve, fiduciary responsibility of funds. There's a reason why a regulation was enacted that says we need to have this reporting requirement. We need to ensure that school districts are enforcing this requirement, and we really need to be able to monitor how these funds are being spent since there seems to be a perception that they can be and are being abused, or misused. So ultimately, yeah, I don't think it's a good parallel. I don't think it's a good analogy, and I think if that was his argument to the court, I think the court would want to point out to him that income tax records are very, very carefully guarded records, whereas financial reporting records, generally speaking, are not.
Right.
And there's something similar. Every year, the state employees get very cranky when a certain Courier Journal reporter publishes all their salaries in the paper, and everyone can see what that employee made, and that is the financial reporting. They know you made this in your salary, this in your insurance, etc. That's a public record. He's not then going and getting their income tax return and showing it. So essentially what you're asking for is, this is the sum or these sums. You're not asking for the secret information.
Right. Suspended or
yeah, social or, and this is kind of the exception they seem to be arguing was, say you have a vendor who's trying to sell a product and they're saying, we bid X sum and this is how it's broken down. And here's our privileged and proprietary and confidential way that we can save you money by paying this much for roofing and this much for paper. And they mark that privileged and confidential. And sometimes those are not allowed into a public record because if the competitors knew the price they were paying for paper, they could compete. But the entire bid sum and how that money is used once the bid is accepted by that public entity, once they say, sure, we take your product and here it is, it's no longer secret. Only the secret sauce was secret, not the sum or the product. And in this case, I see you asking only for the breakdown of the final product. This is how much money, and here's where it came from, and here's how much we're giving you. And people have a very fond relationship with their PTAs, and so people give them money and things. And if we don't have the financial reporting, in my mind, we're sort of opening the door for shenanigans.
And I will say it's interesting too what Anna's pointing out, this particular exemption that they are relying upon is the very exemption that is being raised by both retirement systems in support of their assertion that none of the records of investment managers that those investment managers deem to be confidential or proprietary should be disclosed. And again, it's just this notion that, there is a measure of accountability when you interact with a public agency. It's an unavoidable consequence of interaction with a public agency. Right. Yeah, so again, we'll see how that plays out as far as the auditor's special examination, but it's the same exemption that they are relying on, except in that case you're dealing with these big hedge funds and these private equity firms and all this, and they're asserting that the information that they share under a statutory requirement, that they're required to share, I'm not sure it's statutory, but they're required to share with the retirement systems are confidential and proprietary, but they have the burden of proving that the retirement systems, JCPS doesn't even want to deny it, they want to give it to you. So it kind of upsets the whole analysis when the agency is ready, willing, and able to disclose those records. It kind of throws the law into a little bit of limbo or chaos.
Well, and the argument that Mr. Travis used in court, or one of the prominent arguments that they used, was that it allowed for another competitor to gain access to privileged information. And he used a for-profit marina as an example of these records being accessible, providing the competition to this marina an opportunity to maybe take away some of their market share or what have you. And what are everybody's thoughts on that argument?
I think that's a ridiculous argument. First, because a PTA is not really a for-profit entity out there competing with others for market share. And even if it was, is that really something we want to protect? If there's 5 or 6 parent organizations and they're each getting portions of the funding, great. That just means more involved parties. I think that's carrying that public competition exception way too far beyond it, because once that marina sells itself to the state's going to have all those financial records and release them to the public. Similarly, once the PTA gives JCPA these records, they're part of its documents and files and really no longer proprietary to that entity. And I don't know, not having seen them, but I would be surprised if they had layered those documents with privileged and confidential, do not release, and the type of statements we see in healthcare or politics when people give something proprietary to an agency. Also, the law requires that the public agency have rules and regulations as to how it's going to handle what's privileged and what's not. And I have not seen it, Mr. Travis or anyone else, provide you with anything that says PTA records are secret and confidential and proprietary, and if they provided that after the fact, you'd wonder if they've had that in place the whole time.
Right, and just their desire to designate them as such does not necessarily carry the day. In other words, just because they want to mark them confidential, just like the investment managers want to say, we want to mark this confidential, that carries the day. No, if that were the case, every public agency in Kentucky would mark every single record confidential or draft or whatever, you know, secret for our, not for your eyes, or whatever they would. So in a line of opinions dating back to the earliest days of the open records law, the Attorney General and the courts have recognized that marking of a document as confidential is not dispositive. Right. So yeah, I think that, you know, and I'm fascinated to know who these competitors are. I mean, every person I discuss this with, and I hope you don't mind, I've been discussing it with a few lawyers who specialize in this area of law, they're like, who are their competitors? Yeah. Can they produce?
Question.
Yeah. You would have think that would have been the first thing he would have said. You know, our competitors are, you know. So, yeah.
He alluded that I'm a competitor, Dear JCPS. He's right. On our website, we say, donate to Dear JCPS. Aren't we worth $5? If you spend $5 with your PTA, aren't we worth $5 too? But I don't really. That just means somebody can give $10. Or a different. You know, a different person can support us that didn't support PTA. It's not like we're stealing their $5 away and they're only going to give to us instead of them.
I'm a member of my PTA, and my baby, the littlest kid in my family, is 26 years old. I'm a teacher. We support PTA.
Do they consider the Crumbs Lane Elementary PTA a competition to the Wilder Elementary PTA? I mean,
I don't think the competitor argument works in this case, because it's not like you're competing with JCPA for some advantage or some gift. You're just both accepting public dollars.
Right. You said
and that's not what the competition exemption is for.
I want to clarify. She said JCPA, but she means PTA.
Oh, yes.
Good. About JCPA, another show. No, I'm just kidding.
I had a question I wish I'd asked Mr. Travis, and that was, how would these documents be different than a 990, which is public record throughout the country?
Mm-hmm. And 990s are governed by law, like anything that the Revenue Service or the government requires, but it's a very similar document to that. I guess his argument would be this is not the type of nonprofit that requires a 990. I don't know how he would respond to that. Yeah. Excellent question. You're going to court.
Require a 990.
PTA has to file a 990.
But I think they're a little more of a summary than the financial record.
With a 990, you're not listing your donors, and I get the feeling that it may be the donors' names they don't want, or the donating entity.
This piece of paper is
one page summary. One number for money brought in, one number for money given out, one number for debts outstanding, one number for receivables outstanding, some signatures,
and the end.
I think that's it.
It doesn't look, to me, it has less information to me than a 990.
Yeah, I can see that.
And the former 15th District PTA president's husband was out on social media on one of my threads expressing concern about releasing the PTA leaders' contact information because he said nobody wants to be bombarded with emails from solicitors. So that must have been another concern that they had, but he doesn't know that they redact all that information. Any record I think would have any contact information stricken out.
Again, I think that the Jefferson County Public Schools is very responsible, and perhaps even overly responsible, with protecting what is truly protected information. They're not going to release stuff that they just generally think, nope, we have no business releasing this. Let's just see if we can get away with it. Right. That's not their approach.
Right. You, Amy, you mentioned to me when we were first discussing this that I think there were 3 tests for considering information proprietary. One was consistently stamping it, like you said, always treating it as confidential. And that would mean that every year when these documents were turned in with the state audit, they would have been stamped at that time confidential. And so that was one of the tests, and we doubt highly that that took place.
It didn't take place this year. No reason to believe it took place.
I mean, it didn't take place at Shawnee when I was PTA president. Nobody told me that I needed to mark it confidential. So there's no protocol as far as I know of that. Do you remember what the other two tests were?
Yeah, I mean, and again, just the idea that you mark it confidential is not going to be sufficient, but I will say, you can observe protocols to ensure confidentiality. With regard to attorney-client privilege, if you invoke that exception or that privilege, you have to demonstrate that you observed confidentiality from the beginning to the end, that there's never been disclosure to a third party. So the first element of the exception there, it's a three-part test: records confidentially disclosed to an agency or required by the agency to be disclosed to it. The second part is generally recognized as confidential or proprietary. So generally you're thinking about trade secrets. You're thinking now in the case of the retirement systems, investment strategies, things that would really compromise their competitive position. So it's records confidentially disclosed or required to be disclosed to a public agency, generally recognized as confidential or proprietary. Oh my gosh, I just did lose the third one. I have to think for a second. Oh, I'm sorry, I can't think of the third one, but those are the first two. If I had my phone, I could. But anyway, I as I said, I think that the problem is JCPS does not believe they meet those tests. If they believe they met those tests, they would assert them on behalf of these individual PTAs. And the fact that the legislature has promulgated a regulation that says, file these, we need to know, and we need to be able to monitor that the PTAs are complying with this regulatory duty, that the JCPS and other school districts are complying with their duty to collect them, and quite frankly, we need to know what the accounting is. Yeah.
So one of the things that I want to clear up is the way that the media covered the court case and the filing. Oh, their screen froze. I hope we didn't lose them. I'm going to pause for a second just in case. Your screen is frozen if you can hear us. So we're going to wait for a second until it comes back. I don't think they can hear us. All right. It almost looks like she discovered it was going out. Yeah. All right. Well, we may be splicing two shows together, and that's fine too.
What do we do now?
I think they'll hang up and call back in.
Our end may be okay. Can you hear us? Because we cannot hear you.
It hung up. All right, they'll be back.
Thank you for lending me this jacket. You know how cold I get. I can't believe you're not cold. That's true. They're dumb.
I know. My theory is
they look super guilty.
I know. Well, then that's why I want to clear up the misconception, because people think I sued PTA for records that they have the right to keep confidential. Because the way the media twisted the headline around, and I even messaged Mandy and told her that I was getting all kinds of hateful comments, and she's like, I'm so sorry, I'll try to keep that in mind next time.
Well, no, she doesn't write the headline.
No, but the story also. But yes.
Cracked up too.
Yeah.
Mandy's worthless.
Yeah, she paraphrased me to say that Adelman is concerned that PTAs are flush with cash.
What?
Yes. Yeah. And that some schools, but that's what
you should ask. You should demand a correction.
Well, I did say that I'm concerned that there's inequities. Some have more money than others. I didn't say flush. The phrase flush with cash is what the problem was problematic. And so I got wealthy PTA moms calling me up going, why do you want to tell us how to spend our money? Why do you want to stop us from fundraising? I didn't say that at all.
The other ones need help fundraising. That's all.
And that we're leaving money hanging on rotting on the vine because we don't have, I hope they're coming back.
What do we do, Tommy?
I don't know, I have my D&D on, so maybe if they were trying to call me, that would be a problem.
I love her.
More.
Oh God, yes. I bought my husband an action figure.
There's action figures of her. Hello. Let me turn my stir back on.
Sorry about that.
That is okay. That is okay.
All right,
It happens.
we're back.
All right. So we had a little technical snafu. So this might be a good time to do a little station break and just say you're listening to Save Our Schools with Dear JCPS. I'm Gay Adelman, and
I'm Yvonne Rivera.
And in the studio with us today are Amy Bensenhaver, who is a former Assistant Attorney General and an open records expert, and also
Guru. I think the term of art is guru.
And also Anna White.
Definitely.
Yep. And also with us tonight is Anna White. Anna is an attorney out of Frankfurt. She specializes in healthcare and politics, and you can check out her Miss Anna for Kentucky.
Yes, Miss Anna for Kentucky.
And while we have a chance, Amy, tell us about the Kentucky Open Government Coalition.
Okay, yeah. Well, what is significant about the open records law is there has been such stability since its enactment. In 1976, the law was enacted, and we really saw very few instances where attacks on the law were occurring, where we were seeing the attempt of legislators to restrict the public's right of access. And in the last two legislative sessions, there have been some pretty significant attacks on the law in the area of economic development and personal privacy. So because the law, we believe, is sufficient to protect those rights, a woman in Western Kentucky named Jennifer Brown, who's the former editor of the Kentucky New Era, and I, during the legislative session, were like, we need a voice for citizens in Kentucky. The Kentucky Press Association has adequately defended this law through these years and years and years of its existence. There have been, from time to time, some challenges, but it's in the last two sessions that we've actually seen an all-out legislative assault on these laws and an attempt to really restrict the public's right of access on the pretext of protecting the public. Like, we want to ensure that we can be competitive in the economic development field. We want to be sure that we're not exposing public employees to the threat of harm. The laws have been in existence since '76. The laws are adequate to protect those things. So our goal is just to, again, to provide a citizen's voice in Frankfurt so that the Kentucky Press Association is not sitting there alone at the table, that we can advocate on behalf of citizens, they can advocate on behalf of media, and we can preserve our existing rights under the law and maybe someday even expand them.
Excellent. So do you have a website?
We do not have a website yet because I keep telling people we're in our infancy, but eventually I'm going to have to say we're a toddler now. We are developing a website. Basically, it's a Facebook presence where I do a lot of writing, and I couldn't even tell you I am not a good spokesman for this group because, yeah, it's just the Kentucky Open Government Coalition. Obviously, yesterday we were writing a lot about what had happened with the auditor's special examination of the retirement systems. But I mean, it is literally not a challenge to find something in the news every day. And of course, when your issue arose with the Kentucky PTA, it was a perfect issue to discuss in that context because of the irregularities in how the case was proceeding and how it came into existence. So there was a lot about your case that was especially interesting to me. And Anna and I have been fortunate to work, we know each other. Our connection is her husband, who was my boss under Attorney General Greg Stumbo. Pierce is, like, as I've said many times, without question, one of the finest men I've ever known and one of the best.
I have to agree.
And truly one of the greatest public servants, completely candid, completely open, completely respectful. Something that's become a rare commodity in government these days is the level of respect that administration demonstrated to the state government employees who had served that office for so many years. So that's how Anna and I kind of knew each other, but we didn't really connect until we found some common ground on some issues. Can't remember if she reached out to me or I reached out to her, but we've already kind of worked a couple of cases together. It's been fun because she's got all of the knowledge I don't have, and I have what little knowledge she doesn't have. So we're perfectly meshed.
And that common ground, from what I know about the both of you so far, is justice. You want justice.
Yes.
And you root for the little guy who doesn't have the same access to getting the advantages that the powerful people do.
A sidekick moment for our listeners at home. Can they go to Facebook and follow you on Facebook?
Yes.
Yeah, and I will
page and keep up with you.
If they have questions, if they're more comfortable contacting me directly, I still don't even have a business email address or associated with the coalition, but I'm really happy to talk to them or take their calls or try to help them work through problems. Because again, this is a law that public agencies have ample opportunity to get educated and trained on. Citizens don't have those same opportunities. So if I can talk someone through an issue, and sometimes I have to give them news they don't want to hear. Sometimes the news is not good, but I can be totally candid. I don't have a stake. I don't want to, and I certainly, everything I'm doing now is certainly, free of charge, pro bono. But I will say my email address is, it's missbehaver@gmail.com. MISSBHAVER@gmail.com. That was an email that I got a long time ago, and it's not very impressive, but that's what it is.
Well,
And you're welcome to email me with questions.
we will post the link to your Facebook page as well as your email address and your website when you finally do get one up and running in our comments section of this video when we post it on Facebook. And I don't know if you know this or not, but I do websites. Like, that's what I do, websites and marketing, and I would be happy to put together a website for you at no cost, because
Yeah.
you're doing. So I don't know how far along you are that you've got going, but we'll get you an email address and a website set up right away.
Well, I really appreciate that. Yeah, it's something that we are, because we are brand new, we have gotten a little bit of funding from something called the National Freedom of Information Coalition, but right now we're fronting all of the expenses until that money gets into our account. And so that is an amazing offer, because I know it's a daunting task, but I might be back in touch with you about that.
That sounds good. So before we had our little technical glitch, I was clearing up a misconception that seemed to be spread when Kentucky PTA filed their lawsuit, their injunctive relief complaint, and named me as a real party. The way the headlines read and the technical legality of the whole story confused a lot of people. And I had people reaching out to me saying, "Why are you suing Kentucky PTA?" And there seemed to be a perception that I had initiated. I did initiate something. I did a routine open records request. I probably do 2 or 3 a week. So as a citizen and as a taxpayer and as a parent and a member of PTAs in our district, a simple open records request, any citizen can request these, should not subject you to having a sheriff's deputy knocking on your door to tell you that you're invited. I wasn't required, I was invited. Isn't that nice that it's still an invitation, but it's still intimidating to have someone knocking on your door and serving you papers. They were attempting to serve me. I had their calling cards all over my front door and my back door because they made several attempts to serve. All I did was initiate it through a routine open records request. What caused this to go to court was them filing the complaint and trying to block me from obtaining open records. So I want to clear that up. I did not sue anybody. I was the named party in a lawsuit that was initiated.
JCPS.
Correct.
And you were sort of the...
But I will tell you why it's important that you be a party to this litigation for this reason. JCPS is sort of in the catbird seat here. They clearly are prepared to release these records, but I'm not sure how vigorously they will argue that these records should be released. So the case, the kind of precedential case here is Beckham versus Jefferson County Board of Education, involving 12 teachers who had been disciplined. A request came in from the Courier-Journal, and this is back in 1994. A request, I think that's the year, a request came in from the Courier Journal for those disciplinary records, records that are clearly subject to inspection under the open records law. JCPS properly notified the individuals affected by disclosure, the teachers, that their records have been requested and by law they had to be disclosed. So the teachers petitioned the circuit court to block disclosure of those records. So essentially you stand in the shoes of the Courier Journal, which obviously very aggressively argued for the disclosure of those records. But the significant thing about that case is it does recognize the right of a third party affected by disclosure, in this case, Kentucky PTA. It recognizes that they have standing, but I will tell you, that case went up to the Kentucky Supreme Court, came back down, and the outcome was the same. The records had to be disclosed. And actually, a friend who is quite knowledgeable about this law, who's actually litigated most of the cases in the last 16 or so years, including, the Purdue Pharma case, the cases involving the University of Louisville Foundation, he pointed out to me, he's not even sure they have standing because unlike the teachers, Kentucky PTA is technically not the party affected by disclosure. You could argue it's the individual PTAs. So if 12 of them wanted to band together, like the teachers in Beckham versus Board of Education, arguably, again, that's an argument that can be raised, but this is the point, and this is why it's good that you had Anna, and Anna was kind enough to put you in touch with me so that we could kind of raise these arguments, because otherwise, again, JCPS, they don't really have a dog, I don't want to use that word, but they don't really have a dog in the fight. That's a common phrase. It's kind of politically incorrect. But they don't really have any reason to aggressively pursue this litigation. They're just going to wait for the court to tell them what to do. And maybe they do. Maybe they would like to be completely candid and open, but that's not typically the position of a public agency. They're going to let the court tell them. That was the other oddity in your case, was the fact that Judge Cunningham, who is very well respected, and I'm in Franklin Circuit, so the little bit that I do as far as litigation is all about Franklin Circuit, and of course Jefferson Circuit is so much bigger and so many more judges, so many more divisions, but ultimately, he is so highly thought of, but I think I'll just say, I think he's a little off target in suggesting that this matter needs to be resolved by the Attorney General. This is not an issue that is appropriate, in my view, for resolution by the Attorney General, because the Attorney General should never be in the posture of telling the public that an agency is violating the law by releasing records. Right. His role is to state to the public, this agency is violating the law because it refuses to disclose records. Right. In other words, he's putting the Attorney General in a very awkward position, and I hope they recognize that in the Attorney General's office.
And another point is, you don't have to exhaust your administrative remedies before you go to circuit court. The Attorney General is a nice part of this process, typically, but it's not a necessary part. And so neither party went to the AG in this case and said, hey, resolve the matter and then appealed it. They just took the big jump to ask for that TRO and then the permanent injunction without ever involving the Attorney General. So the court trying to walk it back and send it to an administrative agency who's never touched it and is not required to causes me some questions.
Yeah, and I don't doubt for 1 minute that he did that with good intentions, like his intention of suggesting that you guys try to work this issue out. And I'm glad to know that the attorney that you're dealing with is so reasonable, because that's not always true. There are many attorneys who are not reasonable and not pleasant to deal with. But I will say, I think the call has to be his. He has to determine, and I thought of that third element, whether these financial reports are records confidentially disclosed to an agency or required to be disclosed to the agency, generally recognized as confidential or proprietary, if disclosure would create a competitive harm or would do competitive harm to competitors of the entity that disclosed them. So in other words, there has to be a showing of competitive harm to the entity that disclosed it from his or her their competing, and that's the problem here. We still haven't heard anybody articulate who the competitor is.
Or what that harm could be.
From this fair accounting of income, revenues and expenditures. Yeah.
But that was the argument that they made. And Anna, you're halfway off the screen.
Oh, sorry.
Yes, perfect. We want to see you and your lovely face. So that brings up a really good point because, again, I was referenced as the potential competitor, even though, because on our, also on our previous show, we made mention of a community PTA that is forming by one of the candidates who ran from the floor at the state and the district level and was not chosen. She's going to be heading up a Louisville PTA that is similar to the district PTA. So I guess that's competitive to the district PTA, but it rolls up under the state PTA. And she's already applied for documentation from Kentucky PTA to get this PTA going. So that's not competition. That's more like a franchise, is how I explained it on last week's show. So, but they did mention that. And if that's the case and they see me as the threat and that's why they wanted to stop it because they see me as a competitor, then doesn't that even fall into an opinion piece that I found of yours, Amy, where it talks about it shouldn't matter who. It doesn't matter who's requesting the document.
Right. Yeah, everyone stands. Yeah, everyone stands in the same shoes under the open records law. I always say that is the feature of this law that I really took the greatest pride in. There is no like pecking order of people who have priority access to records. Everyone stands in the same shoes. Yeah. So if it's accessible to Allison Ross or the Courier Journal, it's accessible to you. If it's accessible to you, it's accessible to this lady you're describing. And I think it is accessible because I think ultimately what, you know, even if you could loosely construe the exception in this case, but bearing in mind the statute says a strict construction, strictly construed, to promote the goals of transparency, even if you could say that, then there's overriding public interest in the ability to monitor where there is a perceived problem, where these groups have this duty, fiduciary-like duty of these monies, and that there is a perceived problem there that requires a regulation that they have to report, that mandates a report. I think, you know, that a court would recognize, I hope, that that is an overriding issue that is greater than any asserted privacy interest or competitive harm that might flow from disclosure.
And in a TRO case, usually, I've never seen a temporary restraining order or permanent restraining order case in open records. I've never been part of one, but I have been other restraining orders. You have to come to the court as the party saying, you must restrain them from harming me and competing with me. You have to come with experts. You have to come with a financial analysis. You have to come with the proof of how this harms you. You can't just say to the court, it's gonna harm me, so stop them. And I see that as something that may be missing here. I don't see that they've made any attempt to have such a showing, and I can't envision what that showing would be.
No, I can't either. But I think, Gay, the point you make is really a good one, this idea that, you know, it doesn't matter who you are or why you are requesting the records. You have an entitlement. If the Courier Journal had an entitlement, you have an entitlement. And that is what kind of does create a little bit of concern here, is that they were, that I don't know if Kentucky PTA was notified or if it even existed when Allison Ross made her requests in the past. It hasn't been that long. But the bottom line is there seemed to be no objection to her having these records. Is it, as you sort of suspected, something to do with who's asking and why they're asking versus the content of the record and whether it's subject to public inspection? So yeah, I think you're raising a really legitimate point with that.
So, and that
they claim they didn't know that this happened in 1917.
1917.
I mean 20. Oh my gosh, I am tired at the end of the day.
I don't think Kentucky PTA did exist in 1917.
In 2017,
Definitely.
they say they're not aware that they asked for them, but there was an article.
Mm-hmm.
So they didn't really do much homework, if that's the case. They just wanted to. I felt like it was an attempt to intimidate me. It didn't intimidate me, but it did intimidate my husband. So he didn't like having sheriff's deputies knocking on our door either. You know, it's not a neighborly kind of thing to have going on. So
See, Gay's so moderate. She's not like me. My one regret in life is I was in 2 sit-ins and I never got arrested.
oh, I'm so sorry.
Oh, there's still time. There's plenty of time.
I've never been arrested.
So,
And we call that, in legal profession, we call that the chilling effect. If they take such drastic action against you, that's kind of a shot across the bow to any interested parent or person who wants to know any of this information. And I don't think that's an appropriate function of the PTA or anyone associated with them.
Yeah, there's this concept in a variety of type, like whistleblower type cases or whatever, but this concept of strategic lawsuits against public participation, SLAPP lawsuits, and it happens a lot in the context of open records, where a person who's made a simple request, as you did, is hauled into court or named personally in a lawsuit. I was working with the State Journal here in Frankfurt. They, instead of naming the State Journal, they named the individual reporter, Alfred Miller, who made an open records request to the Finance Cabinet, clearly, again, trying to send that message of, you know, you're messing with the big guys, back off. But we're very fortunate in this town to have two excellent judges sitting on our circuit court who understand and appreciate this law. And based on everything I've read about what Judge Cunningham was saying, he understands and appreciates this law. So I'd kind of like for this ball to be in his court and let him make that determination about whether or not the records qualify for exclusion under the exception they've invoked. I think it'd be in capable hands with him.
Mm-hmm.
Well, and so let's talk about that a little bit, because you mentioned that for our listeners who kind of may not fully understand how this case concluded, I only had 3 days to prepare. I didn't have an attorney. I had some help, obviously, and I've had I don't know how many pages my brief was, but it was a very well-documented brief, I thought.
Thank you.
Thank you. And it had some exhibits and the whole thing, but I didn't know what, I just wanted to be reasonable. And when Judge Cunningham said, he asked me, is this urgent? And I said, no. And he said, would you have any objection to us referring this to the Attorney General's office and let him have an opinion on it? And that's where I probably made a mistake, but I don't really know what I could have done. Could I have pushed him to make a decision?
I think, you know, that is because, you know, a judge in a courtroom does wield tremendous power. There is no question. I think, you know, in the most, I shouldn't say this because Anna's been in the courtroom. I mean, I've virtually never been in the courtroom, but I will say, if there was a way to politely say to him, Your Honor, I don't believe that is a proper resolution here, because we will be asking the Attorney General in this case to rule that JCPS is wrong or violating the law to release these records. That is not what the open records law mandates the Attorney General do. He does not issue advisory opinions on matters in litigation. So you couldn't get this is what I wrote when I wrote for the Facebook page that we have. The Attorney General is by regulation prohibited from issuing an advisory opinion on a matter in litigation. So you're in litigation. Okay, he cannot issue a decision stating that an agency violated the open records law by expressing a desire to release records. That is not his function. Even if an exemption does apply, an agency can waive it. So, and just say, that's okay, even though we could invoke this, we're not going to. It's just not the function of the Attorney General. And that really does sort of create a dilemma. But again, you know, I definitely understand. I think you did amazing. I am impressed that you have the courage. You have courage I don't have to go into court. I spent many sleepless, Oh, okay, yeah. So the main thing, like I said, is you did very well.
Keep on, carry on.
But I will say that, can you hear? Yeah. But I will say that, yeah, if there could have been a way to politely push back on that issue a little bit, it would have been great.
So let's talk about next steps, because as we mentioned, the Kentucky PTA attorney has been very cooperative.
He's very nice.
And I've had a couple of conversations with him since then. After the court adjourned, we did go into a sidebar conversation, conference room, and we met actually there longer than we were in court and talked about a lot of stuff. And some of the feedback I got was basically they didn't like how I asked. They would have preferred that I had gone directly to Kentucky PTA. So this was their way of slapping me on the hand, is kind of how I interpreted that. But so I turned that into, okay, so let's ask nice and see if we get the documents that you claim we would have gotten if we'd have asked nice. And we're kind of supposedly going down that path. And August 30th was the date that JCPS would have had to turn the documents over to me if the judge had ruled in our favor, because they did request extra time because it had been summer. And the same thing, they have to collect from 156 schools, and they have to locate the missing ones because not everybody turns their forms in like they're supposed to. there's been a lot of turnover and all these things, but at least the district, who has paid employees and a protocol to do so in a bank of data that already exists, and all they're doing is filling in the gaps. The request for extra time, I saw no problem with. So August 30th was their, because of these challenges, this was the date they were going to turn it over to me. And so when I talked with Mr. Travis, he kind of insinuated that, yes, by August 30th, you should be able to get your first round of documents, at least by that first week of September. So we're coming up on this date where if I don't see something from Kentucky PTA, I'm going to start to feel like maybe they aren't going to be as cooperative as we had hoped. And now we need to, what is the recourse? What are...
And see, Gay, that is why it's great that you did go to JCPS, because JCPS, without question, is a public agency subject to the requirements of the law. There are enforcement mechanisms that exist in the law to ensure that you're at least you're given your day in court or your day before the Attorney General to resolve this issue. If you're dealing with what apparently Kentucky PTA, a private entity, at least self-identifies as a private entity, then you don't have those rights of enforcement. You don't have a mechanism for pursuing this.
Right.
So I think you did your instincts were great. Either that or Anna was doing some good whispering.
No,
your instincts were great.
I just do a lot of open records requests. I
Well, I didn't know that.
I had no idea that something could ever explode like this.
Well, especially
Yeah.
something that, in my opinion, has less information than a 990.
And
That's a good point.
And
I
honestly,
agree.
I do a lot of open records requests, and then I just tuck that data away. And if I had gotten a response from JCPS with the Kentucky PTA data, I would have filed it away. And maybe later, when I was looking for something specific to say, let's do a comparison between Shawnee and Manual, because that is one of the comparisons I like to make a lot. Then that would have been one of the things I probably would have dug out and shown. And it's not to make Manual look bad. It's to say, we have unseen disparities. In addition to the seen disparities, we have unseen disparities. What can we do to boost up the Shawnee PTAs? It doesn't mean take anything away from the Manual PTAs, other than maybe say, hey, Manual PTAs, can you loan us some of your volunteers for this big event that we have? Or can you counsel this new programs chair and help them put together this really great program for their parents and collaborate and tap into resources and just raise that community awareness. The community can't do better if it doesn't know better. So those were the reasons I was requesting these types of documents. And if I'd have gotten what I wanted, it would have been tucked away. But because this all did explode, now it makes me wonder.
What's there?
It makes me wonder.
Yeah, and Gay, here's the thing. The stakes are always, there's a sliding scale of how important these stakes are. But you see, these records, as you said, just coincidentally will expose potentially disparities in the amounts of money available to PTAs. But you think about the records, the series of reports that Debbie Yetter just did for the Courier-Journal. Disclosure of those records demonstrates that unfortunately the Cabinet for Health and Family Services has not been able to really address adequately the issue of child fatalities or near fatalities in Kentucky. The Herald Leader just did their series on overcrowding in jails and the issues associated with that. These laws really do provide us an insight into the operation of government or the operation, and again, as much as anything, we're not even, from a purely open records perspective, we just want to be sure JCPS is discharging its duty to collect these by regulation. Arguably, that's all, but I love this idea that you're going to be able to argue, look, there is no more sensitive data in these records than there would be in a 990. So if that is the case, yeah, if that, that really goes a long way to proving that it cannot create a competitive disadvantage for Kentucky PTA or the individual PTAs.
Well, and so let's say in a week or so, when the deadline that Mr. Travis kind of gave me as his initial, you should be getting your first round of these documents by first week of September. If that date comes and goes, and I don't get the sense that we're making progress anymore, what are my next steps? What are my alternatives?
I know Anna knows this answer better than I do, but I literally just saw that in the Janine Hampton dispute, the lawsuit with Governor Fisher, Governor Bevin over the issue.
God's ears.
over the issue of, her hiring. They literally notified the court that they were unable to reach a compromise or settlement. They just notified the court by some motion. So I would think that would be the next step.
Yes, I would think you would just file something that says supplement, update, notice. We haven't received the documents, or if you get what I kind of sometimes see in these situations is a cover page that says, here's the document you requested, we've redacted everything, and you get Kentucky PTA, big black spot.
Yeah.
That would be something that maybe you would attach and provide to the court, because the court won't know. The court can only take notice of what is filed with it. You can't call the judge, you can't fax him, it has to be formally filed with the court clerk.
So, but the judge has deferred this to the Attorney General's office. So do I pursue the Attorney General, or do I go back to the judge?
No, I would not.
I wouldn't know. I don't think. I really do think notifying the court that you all are unable to resolve the matter, or that the resolution is unsatisfactory because they've made the redactions are too excessive, or whatever, once you have those documents in hand. And again, I would love to think that they are operating in good faith and they really are sincere, but I like the fact that you have triggered the enforcement mechanisms in the statute, so you don't have to go away. You have options here, and the court just needs to be aware that his recommendation was unsuccessful. You all were not able to resolve the differences.
If the Attorney General wanted to pony up an opinion, they would, but that's independent of what you do. Okay. The Attorney General is unlikely to reach out to you and say, hey, Gray, we're working on your opinion. Unless they had done that and said, please hold off filing anything, you are in court. You are part of this litigation, and keep filing things until you get a final judgment.
Okay, so I didn't get a final judgment. That wasn't what that was?
No, that was a temporary injunctive relief and a request that the parties discuss settlement. Okay. You did. If you get all the documents you want on the 30th, then you can notify the court we've resolved it. They gave it to me. Failing that, there is still an active claim.
Yep. So, and let's say we do work it out and I get all the documents and I go away happy. Has a precedent now been set for the mom at Crumbs Lane who just wants to see her PTA's records?
Yeah, and that is the problem with the settlement proposal, this idea of settling your differences, because what they give, they can take away. In other words, you're sort of relying on their good graces to make these records. They're not going to acknowledge any obligation under the open records law to make these. We're doing this out of the goodness of our hearts. So you could argue that you established this precedent, but it's not a legal precedent, because they're going to assert we're not a public agency. We don't have a statutory duty, and what we can give, we can also take back. So we, in the future, it would honestly be better. I don't want to discourage settlement, because obviously it's a positive here. Relieves you of a lot of additional stress, get you the records. But again, it's not going to resolve this issue, right? For future purposes, for the next requester.
I'm a lawyer, so I like a court judgment. Mm-hmm. You want that finality, a legal opinion that says these are records which are in the nature of records to be disclosed.
So the Crumbs Lane mom right now submits an open records request to the district for the financial records at her school, and JCPS will do what? Because this has happened now, they won't know what to do.
Yeah, they might. I don't know what options they have under the statute other than to notify her, this second requester, that this matter is in litigation. And again, it might require Kentucky PTA to come back in and I don't know, file a second suit, because I don't think their position is going to change. I think they acknowledge their duty to disclose these records. So it does put them in an awkward situation. Let's just hope that does, because it does procedurally complicate things, whereas at this point, you've got a clean set of facts. You did, I didn't realize you were such an experienced open records practitioner, but I will say you did exactly right. There was no deficiency in your request. JCPS didn't try to evade or obfuscate or delay. They just said, it's going to take us a little bit longer here, but I would like to think that we could get a resolution, a legal resolution. Mm-hmm. Let's hope it could be at the circuit court, but if you really do want to something of precedential value, it would have to come from the Court of Appeals. So let's hope it doesn't have to go there, though.
On to the next step, Kay.
Yeah.
All right, one step at a time.
Yes, yeah.
All right, well, I've covered the things that I want to talk about. Were there any other things related to this open records request and this court hearing that you wanted to make sure we covered?
I don't think so.
No.
I think that about covered it. It certainly is a good example of a private citizen taking matters into her own hands and showing people how it's done. So I think, well, it doesn't have precedential effect. Sometimes giving them a good hard pushback will make them think hard before they deny next time.
Right.
And I think it's also a testament to your courage that you did this, that you're willing to take on the biggest school district in the state, and also a testament to, you know, I really admire when people share their skills. I mean, I believe in the great barter system where we should all just share our skills with each other. And so I'm so delighted to be working with Anna again. I think, you know, I think we create a pretty strong team if this thing does proceed. I think you've got a good chance of prevailing. I can't say with certainty. No one ever knows what a court's going to do. But I think you've got, you know, based on everything we've discussed tonight, I even feel better about everything. So.
Oh, good. Well, real quick, if you don't mind, because I've been completely distracted by other things. I saw that some pension open record stuff had come down. Will you give our listeners a quick synopsis of what you've been writing and covering regarding the pension?
Yeah, actually, you know, I got, when I left the AG's office, I was sort of at loose end, so I would just start calling. I think that's how Anna and I got to know each other. I just like, you know, I saw what they did, and that's crazy. So basically, when Ellen Studholz was denied access to the actuarial analysis, I told her I will do anything. I think it's bogus. I was about to use a dirty word, but I was told not to do that. I said I think it's bogus, and I think, you know, you have a very strong case that actuarial analysis paid for by retirement, you know, the document they were ready to discuss the day of the meeting suddenly is a record of the budget director. We have a great case here, but fortunately for her, the group she works with was able to provide outside legal counsel. Well, guess what? They didn't know the law quite as well as I did, so I was able to step in and help them. In the meantime, Ellen has been really, really good about sharing all of the developments in that case with me, you know, allowing me to attend the hearings, review the briefs. And I can tell you that the last thing that happened was, oddly enough, injunctive relief. The governor's office, representing the budget director, basically said, you know, and Judge Shepard has this practice of saying, you know, you've got a right of appeal to the courts, but otherwise you disclose that record within 10 days. So they basically went to the courts and got injunctive relief to hold off on having to disclose the actual actuarial analysis until this matter is fully concluded. And that could literally take years. So when I say that from experience. Some of these open records cases take years. Now, if we see a change in administration, which is a possibility, I have a feeling some of these cases are going to go away. That the governor's staff is involved in resisting disclosure of public records relating to sexual harassment at a number of agencies within state government, records relating to investigated files of Kentucky State Police in the context of trooper misconduct, of police officer misconduct. So we may see a lot of these cases go away. I have no idea, but I will say, yeah, this has been a real, I'm learning from this experience. I'm learning from working with Ellen's attorneys, because I literally did nothing but churn out opinions, and I loved it, and I was, okay, I did a pretty good job. So you know, I had a gratifying career, but now to be able to share what I know with others and have a value to others is great for me, so.
Well, I appreciate it. It sounds like there's some similarities between what Ellen has experienced and what I'm experiencing.
Yeah, right, yeah. And believe me, you're in good company. I mean, you know, if you consider Courier Journal reporters, you know, if you consider they are pushing back, they are obstructing. I mean, Tom Loftus the other day just wanted to find out how much it cost to build the wall in the annex to separate the Democrats from the Republicans. And
yes, that is insane.
Right. He just wanted like invoices and, you know, here and basically they said those records are in active use, in storage, or otherwise unavailable. And that is just so, again, bogus. That is so bogus, because you know, suppose I do, they can hit a button and generate those records. So, you know, there is a pattern of obfuscation and delay, and that is what I think has persuaded our circuit court judges to view these cases with a certain amount of skepticism. It sounds to me like, and I'm only reading between the lines, I don't know Judge Cunningham, but I think he's viewing this issue with a certain amount of skepticism. He understands the value and importance of the public's right to know.
Well, and he used words like nonsense and ridiculous, and
But he didn't use naughty words.
no, but you could tell that he agreed with you on what the Kentucky PTA was trying to accomplish. And just if we had to guess, what's behind? Is it different every time? Is it Citizens United and ALEC? Is it just corrupt? Is it what is behind, in general, these efforts to block open records?
I think it's a power thing. The more sunshine, the more public eyes you let on what you're doing, the more power you're releasing. And I think it's just a fear that you're releasing power by letting other people know what's going on.
And I wrote today because I was involved in these Twitter conversations about the retirement systems and the transparency failures there. You know, the preamble to the statutes written back in the 70s basically says the people in delegating to their servants, you know, the authority to operate government, do not delegate the right of those servants to decide what is good for them to know and what is not good for them to know. The people insist on remaining informed so that they can exercise control over the entities that they have created, the governmental structures they have created. We insist on remaining informed so that we can exercise control, so that they don't control us. We still control them. They are our servants.
Right.
Yeah.
Our government belongs to us.
The thing that I find amazing is I'm a trusting, naive, optimistic soul. But you know, there are other people who would look at this and say, what are you trying to hide?
Mm-hmm. It raises the question.
On the PR scale, it's not real brilliant stratagem.
But again, that is the point, is exactly what I'm saying here. Some of these, you know, when you're dealing, and I am not going to disparage an inmate in prison seeking access to public records, they have very limited rights, but to them, what they are seeking is important. And there again is a sliding scale in the world's view, objectively, of what is important. So financial records of a PTA may not be, you know, records relating to child fatalities or records about overcrowding in jails, but they are important to you, Gay, and they are important for the purpose they serve of confirming that JCPS is discharging its duties, the PTAs are discharging their regulatory duties. It's very important. And then you take it up another notch and you look at Ellen Suholtz and the actuarial analysis. And again, you know, by the time all is said and done, by the time we actually see that record, so much time will have elapsed that its value will have been somewhat lost. And that is what the goal is here, is to, I heard someone say it in another context, but this idea of delay, and hope they go away. Yes. It's just the idea that if we delay long enough, they'll just get exhausted and they'll just walk away. So that's why you have to really be like a pit bull. You just have to grab on and not let go.
I started in 2013. I'm not going anywhere.
Right since that, yeah.
And the other thing is, you know, when they don't want you to see it, it confirms
there's something there.
Yeah, it does make you
think making about this, that we wanted to see if it was true or not, must be true.
Yeah.
At this point, I don't even need to see it. I
call that the red.
True, you'd release it.
I call that the red flag effect. If they deny your request, it's almost like they're communicating to you, you know, on this subconscious level, we got something to hide.
Yeah. I would have just tucked it away and not thought twice about it, but we are.
Now we have to look at it with, as my father was Cuban. He had an expression, he goes, when something was pretty fishy, he goes, you gotta look at it with 20 eyes. You know, now you know you gotta look at it with 20 eyes.
Yeah, absolutely.
Well, we've come to the end of our show. And so we want to thank you, Anna White and Amy Bensenhaver, for being our guests on tonight's episode of Save Our Schools with Dear JCPS. I'm Gay Adelman, and this is Yvonne Rivera. And thank you, ladies, for joining us.
Thank you.
Thank you.